we continue, but I'd just like to say good afternoon to everyone that's online. My name is Justine Anderson and I'm an associate at Carroll and O'Day Lawyers. I'm also on the executive for the Women Lawyers Association and I co-chair the Welcome to the Law subcommittee with Stephanie Lambert, who today has switched hats to become a panellist. I'd like to begin by acknowledging the Wangal clan of the Eora people on whose land I presently am on, and to pay my respects to their elders, both past, present and emerging. I would also like to acknowledge all the different clans on whose land we are all on and to pay my respect to their elders. I'd like to say a big thank you to HFW for hosting this webinar today. And before we get going, just a bit of housekeeping. We will finish at 2 p.m. promptly, so I'd like to get to questions at about 1:45 to 1:50 p.m. So sadly, I'm going to have to be a bit of a clock watcher. Please use the Q&A function that's built into the Zoom at the bottom of the screen, and I'll try to deal with those questions as we progress through the webinar. We have a lot to cover, so let's get cracking. Our first panellist is Her Honour Justice Jayne Jagot. Justice Jagot worked as a solicitor with Mouse and Stephen Jarks from 1992 to 2002, specialising in planning and environmental law. She was promoted to partner in 1997, but left the firm when she was admitted to the bar in 2002, after which she developed a highly successful practice as a barrister. She was subsequently appointed as a judge of the New South Wales Land and Environment Court in 2006. She also served as an acting judge of the Equity Division of the Supreme Court of New South Wales for a period. She was appointed as a judge on the Federal Court of Australia on the 3rd of September 2008. Our second panellist is Sue Chrysanthou, SC. Sue was called to the bar in 2004 and was recently appointed senior counsel in September of 2020. Previously a tip staff at the Supreme Court of New South Wales and a part-time lecturer at UTS, Sue still lectures at the LPAB since coming to the bar. Sue has been in a number of publicised defamation and intellectual property matters, acting both for plaintiffs and defendants. Of note and context to our audience, recently you might have seen Sue in the press as she represented Jeffrey Rush in his recent successful defamation suit. And our final panellist is Stephanie Lambert, partner at HFW. Stephanie is the youngest female partner at HFW Australia and the youngest partner in HFW's team of 16 real estate lawyers. She has received media coverage due to her considerable success after making partner at the age of 35 while on maternity leave. Stephanie's practice focuses on major projects which cross a number of industry sectors with a particular focus on mixed-use developments, title and land structuring arrangements, foreign investment and project financing. Stephanie serves on the WLA Executive Committee and has been a driving force behind the Welcome to the Law 2020 program. So, firstly, let's turn our minds to written advocacy. Some courts pre-COVID adopted an online court in New South Wales and other jurisdictions. However, in light of the pandemic, written advocacy has become a cornerstone to practice. Junior lawyers are engaging in written advocacy more frequently. And as we know, there are certain jurisdictions that solely rely on written advocacy. So my first question for recently admitted lawyers when corresponding with solicitors on the opposing side, also being mindful that some practices people are corresponding with people in other countries.
Thank you, Justine, and thank you for the introduction. I'd like to start out by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land that I am on, and pay my respects to the elders, both past and present. I think as a starting point to written advocacy, we have to be mindful of the professional rules of conduct which prescribe standards for lawyers. So being honest and courteous in all dealings and not making false statements in correspondence. And then from there, it's really about understanding the objectives of why clients hire lawyers. It's so that they can have someone who can advocate them, and really persuasion is what lies at the heart of good advocacy. I'm sure we've all received those long-winded emails and letters which contain a whole lot of irrelevant information, and there's really nothing persuasive about that. I think as a young lawyer, it's best if you take the time to think about what you're trying to achieve in the correspondence. And then being structured, succinct, and engaging is critical. I think from my experience, the less words that you can use to articulate the message, the better it is, because everyone's very, very busy. When I was trained as a young lawyer, I was always taught to use plain English drafting rather than, expressions which are obscure and long-winded, and really to cultivate that type of drafting in all types of writing that you're using, whether that be email correspondence, letters, or other documents. One of the things that I've found to be very effective is that if you have a lot of information to articulate, you should try and relay that in a way that's going to be visibly appealing to your reader. For example, maybe try using headings, bullet points, indentation, tables, colours, grayscale. All of these things are going to engage the reader and really help your position. The other day I was reading a US contract, and if anyone's ever read one of those, it's like 13 lines and paragraphs that are 50 lines long, and it takes so long. You have to sit there and break it all down to figure out what the words are actually saying and what it means for your client. Try and steer away from that. Use lots of indentation, and if you've got one idea, put that into one clause and another idea into another clause. I guess the other thing that I've found is that if you're negotiating or making an argument, you really need to have that supported by facts and legal grounding. And in written advocacy and negotiation, which is what a transactional lawyer will deal with, you need to be able to support your position with legal grounding and facts. It's not sufficient to come back and say, well, not agreed, not agreed, not agreed. It's not a very effective way to negotiate. And I guess on the cultural differences, just being mindful of what practices are and what's usual, and different communication styles and versus, the other day I was liaising with someone in the Middle East and they told me to do the needful, which I've never heard before, but apparently it's quite common, just to say do that what is necessary. So yeah, and if you're unsure about what the practices are or the norm, it's always good just to reach out to somebody and ask.
Okay, and our other panelists, do you have anything else to add?
I would say confirm that I think it's very important in any communication, whatever it is, including submissions to the court. You've really got to know in advance what it is you're trying to communicate. So you've got to be very clear about that, first of all. And then a sort of simple rule of thumb, you can't always do it, but one thought per sentence is not a bad rule to start with. So I'll just say that and hand over to Sue.
If it's communications in a litigation context, and particularly letters between solicitors, my advice, and this is something I learned as a very junior barrister, courtesy of a very excellent female judge called Justice Bergen, you need to assume that every single letter that's written could be seen by a judge at some point. And you need to bear in mind that the purpose of your letter, whatever it is, should always be something that you could put in front of a judge. I've seen a lot of very angry solicitors' letters, and I've unfortunately been in the position where I've had to show them to a judge and been embarrassed that the judge has seen the discourtesy that's going on between legal practitioners in letters. And as a very young barrister, I sat in court and saw Justice Bergen get very angry with the solicitor on the other side in a matter that I was in because of the content of a letter that he'd written. So I think courtesy is key in correspondence. And I've had many matters where matters have settled or people have agreed to positions because they've engaged in courteous correspondence with their opponents. And that isn't just formal letters, that should include emails as well and any communication. The other lesson I was taught as a very junior barrister by, in fact, a very senior partner from Mallison's, which I'm sure the judge knows. He said, if a letter's longer than a page and a half, it's probably too long.
Yeah.
And I think there's a tendency that solicitors use definitions and they repeat themselves, and they are trying to cover every issue in these lengthy letters. And I have to say that I haven't seen many occasions in the last 17 years where a letter that is longer than a page and a half has been worth reading. So I think that's important from the advocacy perspective, because you lose your audience, whatever you're trying to achieve, if the document you send through is too long.
Absolutely. And I think all of the answers that you've just given kind of speak to the next two questions. I thought that maybe briefly we could discuss tone of correspondence, but I think we've covered that off by addressing that you have to be courteous, being succinct, using plain language. I, as a solicitor who correspond with other parties in litigation, always tend to take the view that it's better to be nice, or you catch more flies or bees with honey, whatever that expression is, than you do with vinegar. And to your point, Sue, I have definitely been able to mediate matters because I've got a good relationship with defendants, as opposed to some other war stories that I've heard where people have been nasty or dig their heels in unnecessarily. And in terms of, we just touched on it earlier, and I think it's something that needs to be explored. And it's a question about legal privilege. So you were saying, Sue, before, and I'm sure Her Honour can speak to this, when practitioners use legal privilege or attempt to use legal privilege, when can it stand up, and what are the common pitfalls that solicitors or junior lawyers might fall into by using or attempting to use legal privilege?
Well, first, can I agree with Sue that it's a good assumption that anything you write, even if it's without prejudice, even if you think it's going to be privileged for some reason, if you write it to your client, that for whatever reason, at some point in litigation, whether it's because something's settled or it's an argument about costs or it's an argument about whether an agreement's being reached in fact, or there's been a waiver by conduct of some part of a chain of correspondence, and therefore the other parts of the chain also have to be produced. Things that you think might never find their way into the public domain and you never anticipated might find their way into the public domain do. And that can be very embarrassing. And people do have a sort of strange view that if it's in an email, somehow the normal rules don't apply. Because there's no doubt that you see things written in emails by lawyers that they would not, ever want to be made public. And it can be very embarrassing. So I think the rule that Sue just stated from Justice Bergen about assume everything you put down on paper could be published at some point is a pretty good discipline. In terms of using legal privilege, I think we've all got to recognise that it's an issue that's capable of genuine argument in situations. So things you think are privileged sometimes are not. And that just reinforces the rule that, if you don't think it can withstand scrutiny by the public or by a judge, you probably should look again at what you're putting on paper. This includes all things like file notes and all sorts of things that you wouldn't think ordinarily would get deployed in litigation, but they, for whatever reason, they do, for all sorts of reasons. And I think you've got to be aware of, as I said, the doctrines of waiver by conduct. That is, in effect, you can't deploy the bit you want to deploy and nevertheless maintain privilege over the balance. You might, and that happens in affidavits, in correspondence, in all sorts of contexts where a person has deployed, as a lawyer, solicitor usually has deployed something which would otherwise be privileged, and then the legal effect is to waive the privilege over the whole chain or other explanatory documents which they they probably never intended. So you've got to be aware of that doctrine, I think. Yes, I've seen, in terms of the question, I have seen people attempt to use legal professional privilege when it doesn't apply, but it's, as I say, it's always been an arguable proposition, and there can be quite hard fought arguments about whether something is in fact privilege, the purpose for which it was created, or alternatively waiver, which depends on the facts as well.
So do you have anything to add?
Well, yeah, sure. And importantly, if there's going to be an argument about privilege, the judge has to look at the document anyway. So even if it ends up being privileged, the judge has seen it and can't forget and can't unsee. So if it's a nasty piece of correspondence, it's still there, whether it ends up being privileged or not. So I stick to my earlier rule that you just have to assume everything you write could end up in front of a judge one day or otherwise published, and you need to write your correspondence bearing that in mind.
Yeah, I think it's a good rule of thumb. Steph,
Yeah.
in a transactional setting, what advice do you have for any recently admitted lawyers when corresponding with a client?
Just to go back on Sue's point as well about correspondence, you know, lawyers have professional rules of conduct that require them to remain objective and to not, you know, to avoid personal bias. So it's really important to think about that as well when you're doing correspondence. So, you know, the tit for tat strategy and getting into those sorts of arguments is to be avoided. I think in terms of client communication, it's about understanding the client and how they like to communicate. Some clients that I've dealt with like to have a lot of context in correspondence. Others prefer brevity. I think, you know, some like to be addressed very formally. Others prefer to be informal. But, you know, going back to the conversation that we had earlier, you know, just to be mindful of the fact that that correspondence can be brought up at any point in time. So as a young lawyer, I think it is important that you do get client contact, and because it will develop your, you know, sense of self-confidence and also greater feeling of autonomy and satisfaction in professional development. And I guess what comes with that is, you know, a sense of, well, what if I make a mistake, or what if I don't know something? You know, it's very important to realize that, yes, people do make mistakes. Not everybody knows everything. Mistakes are going to happen in your career. It's just a matter of fact. It's about how you deal with those. And, you know, if you don't know something, don't pretend that you know it. Just say, or leave it with me and I'll get back to you. I mean, even in my career, I do that now. If I don't know the answer to something, I don't think, you know, the clients are very understanding. I don't think they're expecting you to know every single thing.
Perfect. And that leads into my next question, which is what happens when you make a mistake? You know, whether it's embedded in a document, you've accidentally maybe omitted a word or put in a word that shouldn't be in that clause, or possibly you've misspoken. I suppose we'll speak to that in oral advocacy, but in terms of written advocacy, possibly in litigation, if people have, you know, possibly written the wrong thing in submissions, or they've consented to the incorrect order or an incorrect date. How is it best for junior lawyers to deal with those mistakes, particularly in a written context?
Admit the mistake straight away to someone who can fix it. Immediately tell someone.
Steph, how do you deal with that at a partner level?
I mean, ultimately, it's the partner who's signing off on the documents. So if the mistake's in the documents, probably because the partner hasn't checked it enough. You know, it's just like what Sue said. You just have to correct it straight away.
And Your Honour, have you experienced that in your time on the bench?
Oh, plenty of times. People have, you know, sent some communication that's not correct, or they've said something in oral submissions which is not correct. And Sue's advice is right. You've just got to correct the record as soon as possible. You don't leave the mistake on the record. That's all there is to it.
All right, well, we might move on. Okay, so we've kind of already covered this off, but maybe in this context, we might have a few extra comments. When writing to the court or writing into a tribunal, what are the basic do's and don'ts, either by way of email or writing letters to the court or potentially to a tribunal.
There are actually some practice notes about this that people should check up on.
Yep.
I was in the federal court recently where a judge was very upset with a solicitor for not complying with the proper processes when communicating with the judge's chambers. I mean, the first thing is, and it's really important, you shouldn't send anything to a judge's chambers without informing the other side and getting their permission first. And I think that's a rule that I see breached on a daily basis by solicitors. And it makes people a bit upset. And to the extent that anything's written to a judge's chambers, it shouldn't include any form of submission whatsoever unless the judge has invited it. And again, shouldn't be sent without the permission of your opponent, including what I usually do is actually prepare a draft. I don't just tell them I'm going to write or my solicitor's going to write. I actually submit a draft to the other side and get them to approve it before it's sent. Because there's no occasion that I think parties should be communicating ex parte with the court without first getting the approval of their opponent. And if they do have to do it, and if everyone agrees there should be a communication, it should be short and uncontroversial.
Yeah, I can endorse that. This is a rule breached routinely, and particularly, I have to say, by solicitors. This is a rule that barristers seem to be much more aware of than solicitors. But the basic rule is you don't actually communicate with chambers or a tribunal or any decision maker like that unless it's with the permission of the other side, and you absolutely have to. If you don't have permission of the other side, then the basic rule is you need to file an application rather than sending off correspondence. The other thing that's always annoying is where you get two separate emails from, one from one side who's saying their thing and one from the other side that then says their thing. Apart from the fact that it's very likely that it's breached the first rule, it's just, completely inappropriate to sort of enter into a debate or a dialogue happening, which is really directed to the other solicitor, but happens to include the judge's chambers. But that happens not infrequently too. So if it's absolutely necessary to communicate, I totally agree with Sue. The really only proper way to do it is you actually agree the terms of the communication with the other side. Now that agreed communication, as I've had to make clear to some people, can include the agreed fact that you disagree about something. You agreed fact that the applicant's position is A and the respondent's position is Y, and you need another date. Or you would like the court to resolve this, but you don't need a hearing or something. But you can agree to disagree in a single joint agreed email, and that's really the only way to do it. And the other thing is, as I say, the rule is you actually, unless you absolutely have to, unless you've exhausted all efforts to work it out with the other side, don't bother the court or the tribunal. If you do communicate, of course, you've got to copy in the other side. You've got to be brief. You've got to be accurate. And an important one is, and this happens a bit too, unfortunately, is there can be an unintentional representation made that something's by consent when it's in fact not. And that includes even, for example, the solicitor, say, intended that they would obtain the other side's consent. So the orders that they attach actually have consent order on it, but they're not actually agreed. And the very word consent on the order is sometimes enough to make it go off the rails and for the judge to think, well, that must be by consent when it's not. So I think you ought to be really careful not to sort of represent in any way that something you're doing is by consent if it's actually not by consent.
Yeah, I've seen some of that stuff happen too in the common law lists in the Supreme Court. And I agree with you, Sue. They've just redone the practice note in the professional negligence list, which is where I mainly hang out in the common law list. And it makes my eyes water sometimes when you do see things being sent off to judges without consent or people using consent orders instead of short minutes of order. And it's not clear that things are actually in contest. So I'll put this question to the panel. What is the best piece of advice that you've either given or received in relation to written advocacy? Steph, I might start with you.
Just to keep things as concise and objective as possible, you know, keep the word count down. Just think about what you're trying to articulate before you put it in writing, and put a framework together about how you are going to articulate that. Do that in the way that's most visibly appealing, because, you know, it will get read and be more compelling if it looks like that.
Judge?
I would just say structure, structure, structure when it comes to written advocacy. If it's not structured, it's almost impossible to read. So you really think about the structure and, you know, liberal use of headings, subheadings. Be very, you know, what is the proposition you're trying to prove in this part of the submission, or have accepted in this part of the submission, and, you know, make all your points about that, so that there's a logical structure to how your written submissions build upon each other and end up with the final result that you want.
Sue?
If you've got 2 good points, don't hide them in 10 bad points.
Yeah, I've heard that one before.
Delete
All right, we might
bad ones, delete the bad ones. You're allowed to get away with maybe 1 or 2 bad ones, but not half a dozen.
We might move on to oral advocacy. So I think, as we know, preparation is key for oral advocacy, and advocacy in any form. But when you're standing in front of a decision maker, answering questions, or potentially, you know, giving your submissions, preparation, I think, is obviously crucial. So, and I think also in light of COVID, much has changed. We've now got appearances by telephone, we've got AVL links, we've got hearings that are taking place via AVL, which have had mixed reports of success, mediations by Zoom, and sometimes, occasionally, people are still allowed to attend court in front of people. So I guess my first question is, has Zoom or AVL influenced the practice of law in a positive or a negative way?
Well, I'll make the point. I still, you know, I think all of my hearings, bar one, have been online since March, and the one that I did have where people were in the courtroom was a hybrid hearing. In any event, there were a set number of people in the courtroom, and we were still on screen, and which I thought would be very distracting to have people in front of you and also on the screen like a witness or whatever, but actually worked out pretty fine. I'm strongly of the view that, yeah, whether it's in person or online, you know, good advocacy is still good advocacy, and bad advocacy is still bad advocacy. So I don't think that it's substantively made a difference. You know, what's good in person to me is good online. I think the only thing that you need to be more aware of online is, and I don't even know that it's more difficult, but, you know, some people do this well in person and other people don't do it as well in person, and the same thing online. It's more important, I think, online to make sure that you are looking at the judge and trying to work out whether they're with you, as in not with you in terms of the argument, but are they up to where you're up to? So when you say go to a document, you know, it may be easier if you're in person to see a judge flapping around trying to open folders and not finding a document, whereas everything's online these days. So the judge has got a screen here and then a screen there, and they've probably got the documents online, a lot of them. And so you're saying go to this document, and it's harder to tell whether the judge is actually up with you or not. And you don't want to get, you know, ahead of the judge or be saying complicated things about a provision of a document in circumstances where the judge actually hasn't even, you know, either hasn't found it, or, as not infrequently happens, you know, for whatever reason, the document won't open on the electronic version and faffing around has to be done. So I think it's, you know, I think you've got to have the confidence to say, I'm at document, whatever it is, paragraph or page, whatever it is Your Honour with me? You know what I mean? Or something to make sure the judge can say, well, slow down, actually I'm not, we're having a problem. Because if you just keep talking and barreling on without making sure the judge is with you, I think in a remote hearing, you can leave the judge behind more easily.
Sue, what's your experience been?
Well, I've had back-to-back trials and appeals since March. Like as soon as the courts shut down, I had a trial, 2 trials in the federal court over those 2 weeks. And then I've had mediations, I've had appeals, I've had special leave applications. So it's been non-stop on video. The only hearing I've had in person was a 4-day federal court hearing, which was a hybrid hearing as well. It was the barristers and solicitors were in the court, but the witnesses were appearing by video. I have not really had any problem running cases from home. I haven't found the only time I'm about to find the AVL a problem is I can hear my mother coming in the door, and I know the poodles will bark. That's the main problem I have when I'm on the video. I can hear it coming in now. The dogs are barking. But that's the poodles have become well known. But I think the only time I found it very impossible to run an AVL hearing was in the Court of Appeal a couple of weeks ago. And I actually raised it with the president last week. They had a video that didn't actually show the faces of each judge. So they had the video back. So it was this huge, like a theatre, like they were down on a stage and you couldn't see their faces. You couldn't even tell which judge was talking. So you had to guess which judge you thought, if you could recognize their voice, which one was actually talking to you. And I just thought it was hopeless because I had no sense whatsoever as to if the judges were keeping up with me or what their response was to my submissions. And I think just like in court, on video, you need to pay close attention to the judge, or if you're cross-examining or taking evidence, to the witness as to whether or not they're keeping up with you and what their response is to what you're asking or saying. And funnily enough, I found that easier to do via video because their face is right in your face. I mean, in court, the judge and the witness are further away. Whereas via video, and I've had to cross-examine a lot of witnesses via video in the last 6 months, the witness's face is right in front of me. So I haven't seen it as any disadvantage in conducting evidence, cross-examination or examination in chief or making submissions. So I haven't had a problem with it, but I know some barristers struggle to run a case sitting down via video, but I've actually found it better in some respects.
Steph, do you have anything to add?
Just from a sort of transactional point of view, I think it's been quite good. It's allowed us to be able to fit more meetings in, actually, because usually you're sort of running around from office to office. But aside from the IT issues that sometimes are experienced in, freezing or not having the right sound or getting feedback, it's been quite good overall, I think, from my point of view.
Yeah, I agree. I haven't had issues. I did an online mediation. It went really well. I was with clients, everyone was kind of scattered throughout New South Wales. It was fine. So my next question is, what is commonly seen to go well and to go wrong in oral advocacy, whether that is in its pre-COVID, more traditional turning up physically, or post-COVID with this, online kind of modality that we're all using? And by that, I mean, is it, announcing appearances? Is it seeking leave? Is it addressing a particular member by using the incorrect title? Equally, so kind of thinking about what has been seen to go well and what has seen to go badly in oral advocacy. We've had another question come in about tips about how to manage anxiety and when you're advocating orally, because I think that anxiety and, stage fright, for want of a better term, is something that can really impact people when they're attempting to advocate.
I think things that can go wrong are like a lack of flexibility. The worst advocacy I think that I've ever engaged in or I've ever seen is when you stand up and you have a fixed idea as to how you're going to present your argument, and the judge, as they do, throws you completely off course, and wants you to start somewhere where you didn't want to start. And I saw that happen to one of my opponents in the Court of Appeal a couple of weeks ago, where he had decided to start on one topic, and one of the judges said, well, hang on a minute, we don't want to start there, we want to start here, which happens in the Court of Appeal because it's 3 against 1. And he, I think, was surprised by that and found it difficult to adjust his arguments, and it put him off for the whole morning. So I think you can avoid that, and this comes into the anxiety question that you've asked as well, if you prepare as much as possible, and if you prepare on the basis that you can, and if you're the sort of person who likes to have notes, that those notes are not linear, that they are in different topics and you can go back and forth if you need to. One of my tutors used to have circles on a page with the different topics, with more detailed notes on separate pages. So I think you need to be prepared to be flexible, and the only way to be flexible in an argument, particularly if it's a difficult or technical argument, is to have prepared it properly and to know your material. And I think that will avoid a huge pitfall when the judge wants you to focus on something you don't want to focus on first, but it also lessen your anxiety, because if you feel prepared, then I think you're automatically generally going to be less anxious. But also, I mean, there's nothing wrong with being anxious. I had a big case against one of my friends who's a senior counsel, and we were talking about being nervous before court or nervous before cross-examining. And I was telling him, I'm nervous about cross-examining one of your witnesses today. And he said, I'm glad you've said that, because I'm still nervous too about cross-examining witnesses. So I don't think there's anything wrong with nerves. I think if you're not nervous, then you're being maybe a bit complacent. But those nerves can be tampered down a bit, I think, if you're prepared. And if you really have a bad time, like if a judge says something to you, or some judges, unfortunately, not this judge, but some judges shout at you or are very rude to you, that can throw you off course. Again, not mentioning any names, New South Wales Court of Appeal. Sometimes that happens, and you need to cope with that. And sometimes the best response is to have a sip of water and take a deep breath. This is what I tell witnesses. Take a moment to have a glass of water and then just address what you need to address calmly. In the end, all you're doing is talking. I mean, you're not going to be shot or anything. You just have to remember that you're just there to make an argument, and it's not always going to go perfectly, and to not beat yourself up too much about that.
Judge, what do you have to add?
Well, I certainly had advocacy anxiety, and I developed a technique where I sort of conceptualized the court as a theatre and myself as a role player in the theatre who had a particular role to play. So it wasn't like it's really me standing there doing this, it's me performing a part. And that gave me some distance, I guess, from the experience that I was performing a role in a particular kind of public play. That's not to diminish the importance of what we're engaged in, but I did find that, and obviously, if you're not prepared, right, if you're not in mastery of your material, it's going to be, it's terrifying. You know, it's where your stomach's sinking through the floor because you really don't know what you're doing. So you've got to be prepared. And one of the, just coming back to the what's done well and what's not done well, this is more so in what I would call case management type situations as opposed to hearings. You know, mostly people are all prepared for hearings, but surprising how many people turn up who are not really prepared for case management hearings. Basically, people can turn up and they actually don't know exactly what they want from the judge. They're there, but they don't know, you know, what I want you to do today, judge, is this. Make this order, do this. So that's not uncommon. They're not exactly sure why they want that thing and how it fits in with the whole progress of the litigation. And they're not prepared in the sense that they haven't worked out what hurdles, legal hurdles or factual hurdles, that they actually have to jump over in order to get the judge to do what they want. once they work out what that is. So they're very basic things for case management. You've got to get it in your head. Why are you there? Why do you want something? And what do you have to get over in order to get what you want? And you've got to know all those things before you turn up for any sort of case management.
Absolutely. I've seen it fall over, and I've seen it done really well as well in case management lists. I'm just conscious of the time, and there's a few questions that have come through, and some of the questions that I'm yet to ask might actually answer some of these questions. So I might start with you, Steph. Is there anything else you want to add about oral advocacy in relation to transactional law?
I just go back to what Justice Jagot was saying before, in that you really need to be a mastery of the documentation or your case. In a transactional setting, the oral advocacy will be, for example, if you're going to negotiate whatever the document is with the other side, you need to be familiar with how the document works, what your client's position is, and you need to be able to articulate the reasoning for, I guess the best type of negotiations that I've seen is where people can articulate their client's position in a very holistic sense. So give background and context to the situation and work up to how the parties have found themselves in this position, what your client's position is, and be able to tell it a little bit like a story, so that it's people can understand it. You need to know what's important to your client, what you can let go, and also just really understanding how that contract works, because I can't tell you how many times people have been tripped up by small things like interpretation provisions or general provisions where a clause that they've inserted into a document hasn't necessarily worked out the way that they thought it might work out. So yeah, just being very aware of and prepared for what you're going to negotiate.
Thanks, Steph. This is a question that has kind of been asked of us through the Q&A portal, but it's also one that I wanted to ask, but I'll just amend it slightly. What do you do if a lawyer is behaving badly in a courtroom? So whether that is a judge that's yelling at you, or a barrister might be speaking over you, or you might feel intimidated where you're kind of, as a junior lawyer, being bullied into a position, whether that's in case management or possibly if you're at a notice of motion or whatever it happens to be, if you've got a very senior silk and who might be appearing for, say, a case management thing, or it might be a notice of motion, you might have a junior lawyer there. What do you do if lawyers behave badly? How do you address it? How do you possibly bring it to the attention of the judge or the decision maker? And also, what happens when it's the decision maker that's acting inappropriately?
Well, I think I was, when I came to the bar, I think I was 23 or 24. So I often was, I was attempted to be intimidated by my opponents before going into court in negotiations or in court. And I think the thing you need to remember is it doesn't matter who they are or how senior they are, or if they're a silk or even if they're a judge. You just have to remember from an advocacy perspective, what you're there to achieve for your client. And that you shouldn't let anyone else's behaviour affect your game plan. You shouldn't let anyone else put you off from the submissions you need to make, and the manner that you've chosen to make them, including your tone and the order that you want to address things. If there's a practitioner outside of court trying to bully you into agreeing to orders before you go into court, which happened to me many times, I think you just need to step away from that and just say, well, we're not going to agree, so I'll see you in there, and not be rude and not and just try and ignore that sort of conduct. I don't think it helps going into court after an exchange like that and having a cry to the judge. I just think that often that just doesn't help. I mean, it's not the judge's role to manage, in my view, interpersonal problems between lawyers, and the judge doesn't want to hear about that sort of stuff. I think you need to, when it's happening in court, and I've been guilty of this and been told off because you get frustrated and tired sometimes. If someone's interrupting you, one thing you can do as an advocate is just sit down and let them interrupt, and the judge will deal with it if it's an appropriate interruption or not. Or you can ask them not to interrupt you. When we're actually in court, I've often, when I've had someone interrupt me, put my hand out to them and ask them to please be quiet and tell them that they'll get their turn. Or depending on what's happening, I've sat down and let them interrupt. It just sort of depends on the situation. But as I said, the main thing is to not let it interfere with what you need to do. There's a lot of bullying at the bar table, which happens less now via video. It's not as easy to sledge someone when they're not sitting next to you. So there's a lot less of that I've found in the last 6 months, which is good. But if it's the judge who's having a go at you, I think it depends how senior you are. I think if you're very junior, there's very little you can do about it. And then you just have to stay calm and just keep making your submissions. I've seen more senior people, particularly female barristers, say to a judge that they didn't think that the judge was being polite to them. That doesn't always go down well. So I think if you're very junior, you shouldn't respond like a very senior person would. I think if you're very junior, you just need to take a deep breath and continue with your submissions. And if you think it's really bad conduct, like if the judge is really treating you in a way that you think it amounts to bullying, then you should tell your superior about it when you leave court. And something might be done about it. But I think when you're in court and you're junior, you should not be having fights with judges. You need to just take a deep breath and finish your submissions and get out of there.
Judge, what do you think?
I think it's still the latter point. I mean, it's obviously, not acceptable if someone in a position of power is in fact bullying you. And but when you're actually in the situation, as Sue said, particularly when you're very junior, it can be very hard to, in a way, front the judge about what they're doing and their behaviour and its impact on you. But ultimately, you do have an obligation to your client. And I think most judges would respect the idea or being reminded gently that I still have to do my best by my client and put these points to your honour. And that's the bottom line. And if judges need reminding of that, then I think you've got to remind them of that. If it's in the middle of oral advocacy and it's your opponent, again, as Sue said, sometimes on the opposite side, you actually do have to interrupt your opponent because your opponent is saying something, not just that you disagree with, but that if it were corrected, they're clearly got the wrong end of the stick. And if it were corrected, time will be saved. If they think you oppose, for example, something and you actually agree with it, rather than going on for half an hour about why you should do something that you in fact agree with, where you do need to sort of say, well, I don't wish to interrupt, but need to say that that's not opposed, or in fact the true position is X or whatever. So that's okay. But if it's a sort of gratuitous interruption, again, I think what Sue said's right. You can say, well, my friend will get his or her turn and it's my turn now. Or, as I've seen done very effectively, just sit down, let them run out. And, the judge will say, all right, well, now back to whatever. And if it's continuous interruption, often the judge will say, no, I really need to hear from Ms. or Mr. X. You will get your turn. And often if it's oral advocacy and there's sort of sledging or, those not so sotto voce whispers or whatever it be, the judge can often see that because you've got a sort of panoramic view and, you've got to be, it can be distracting to the judge as much as anything. And the judge may well then say, look, we really please don't, and we really need to get on with this.
Speaking of, we've got 7 minutes left and there's a few questions to get through. As briefly as possible, can you give us some of the best piece of, like the best piece of advice that you've either given or received in relation to oral advocacy? Might start with you, Judge.
Oh, okay. So just from my point of view, it's important people don't speak too softly. So if you're really straining to hear someone, it's actually quite difficult. And don't speak too quickly. I mean, the speed with which people give me anyway, case citations, you know, blah, blah, CLR, blah, blah. And often you think, well, this is the sort of matter where I need to go back to the transcript. I'd really like to get a note of that case citation. You just can't, you know, they speak so quickly, you can't get it down. So I think a measured pace is really the go. As I've said, keep an eye on the judge to make sure they're up with you. So don't just be obsessed with your own, what's happening in your space. You've got to look at what's happening with the judge. Always be concise. And also you just can't assume the judge has read either everything or necessarily anything, depending on what kind of matter it is. And if in doubt, you ask the judge, you know, has Your Honour had a chance to read this material, or should I assume that Your Honour's read this or not, you know, and then you tailor, you know, if they've absolutely read everything, it's an interlocutory application and it's, you know, unopposed or whatever, you know, you tailor what you say based on, okay, I have had a chance to read everything, or I've had a chance to read nothing. You really need to tailor, be ready for whatever the position is.
Sue and Steph, do you have anything to add?
If it's submissions, listen to the judge and listen to what the judge is asking you and saying to you. And if it's the witness that you're cross-examining, listen to the witness. I see so many barristers who cross-examine witnesses and they have their questions written out and they're not actually listening to the answers. You need to listen to what's going on around you, and you'll be comfortable and able to do that without being fixated on your notes if as I've already said, you're prepared and you're flexible. And they all go hand in hand.
Steph?
I would just add to that, you know, just don't talk for the sake of talking. If you've got a point to make it, but if you just are there for the sake of talking and it's not going to make any point and it's not achieving your client's objectives, just don't say it.
So you touched on this before, and this is a question from our audience, but what does the panel think about appearing by video where the judge and your opponent can see all of your micro-facial expressions and interactions with juniors? Like, does now the access to, as you say, being able to see people's faces close up, has that changed advocacy for you, Sue, and also for you, Judge?
I always use my facial expressions as a tool, particularly when I'm cross-examining witnesses. And I have found it fun that the witnesses can see my face close up. My juniors are not with me. As you can see, I'm at home. And my juniors are either in their own chambers or at their own homes. And they are sending me messages that appear on my screen in front of me as I'm cross-examining or making submissions. So the interaction with my juniors is a bit different, but sort of much cooler because no one else knows that my juniors are sending me messages. Whereas in court, it's obvious when your junior's trying to talk to you because they're either passing you a note or trying to talk to you. So I actually found it quite fun that I found that dynamic quite fun, that these messages are appearing in front of me from my junior. Sometimes my reaction would show that I'd received a message, but I find it quite a fun technique to have that different interaction with everyone in the court.
And Judge, sorry, I'm just conscious of time, so I don't want to cut you off, but Judge, for you, when you're seeing people give evidence, is it something that you have used to try to discern whether someone's being wholly truthful or not?
I haven't found it particularly different from in person. Mostly I've had a pretty good view of the witness online. So I don't think it's any different. The only other thing I'd say is that even in court, I find nothing to do with interactions between a barrister and a witness, but, you know, when one barrister's speaking, I find it distracting if the other barrister is, you know, doing a lot of head shaking or audible sighing and hair tearing, you know, as though this is the most outrageous thing I've ever heard. And they're demonstrating that in all sorts of visual cue sort of ways. I find that quite distracting. And on screen, it's probably even more distracting.
Mm.
So I think you've got to be careful to sort of maintain an aura of measured calm.
Final question. Does the panel have any advice for women in the law? Judge?
I would just say be yourself. You don't have to be anything other than what you are. Your own personality, just be yourself.
Sue?
Yeah, I agree with that. You don't have to, just because you're a woman, try and be more aggressive or more difficult to assert your dominance over the world. I think being yourself is the most important thing. And if you're struggling with the behaviour of men around you, to seek the support of other women around you who are supportive of women. I think it's important to talk to people. I mean, we've had a lot of controversial things happen in the last few months. And if, as a woman in the law, you're struggling with how men are behaving, then you should tell someone.
Yeah, I agree. I agree with all of that. And also just to have confidence and back yourself and believe in what you're doing. Having a good mentor is also invaluable if you can find one of those, because they'll be able to teach you, you know, how things that you wouldn't necessarily know and help you with your career development along the way.
Absolutely. All right, well, it's 2 p.m. I'd just like to say a big thank you to the panel. We've all learnt a lot of lessons today, and I'd just like to thank you again for coming and spending your time, and a big thank you to HFW for hosting us. This will be recorded and I will send out a link when the recording has been uploaded.
Thanks so much for all that.
Great. Thanks, everyone.
Thanks, everyone.
Bye.
Bye.
Bye.